Good day to everyone, and I'll be discussing today about Republic Act number 11362 or the Community Service Act. Now, I'd like to go through with its statutes first before I discuss about the Community Service Act. RA 11362, an act authorizing the court to require community service in lieu of imprisonment for penalties of arresto menor and arresto mayor. Section 1, this act shall be known as the Community Service Act. Section 2, the policy of the state is to promote restorative justice and also to decongest by authorizing the court in its discretion to require community service in lieu of service in jail for offenses punishable by arresto menor and arresto mayor. Section 3, Community Service. Article 88A of the Revised Penal Code is hereby inserted. Article 88, the provision of this is that the penalty of arresto menor shall be served in the municipal jail or in the house of the defendant himself under the surveillance of an officer of the law when the court so provides in its decision, taking into consideration the health of the offender and other reasons which may seem satisfactory to it.
Section 4. Implementing Rules and Regulations. The Department of Justice and the DSWD shall issue the rules and regulations to implement the provisions of this Act within 90 days from the effectivity of this Act. Section 5. Repealing Clause. Chapter 5, Title 3, Book 1 of the Revised Penal Code hereby amended, and all laws, decrees, orders, rules and regulations, or other issuances or parts thereof inconsistent with the provisions of this Act are hereby repealed or modified accordingly. Section 6. Separability Clause. If any portion or provision of this Act is declared unconstitutional, the remainder of this Act or any provision not affected thereby shall remain in force and effect. Section 7. Effectivity. This Act shall take effect 15 days following the completion of its publication, either in the Official Gazette or in a newspaper of general circulation in the Philippines. This Act was published in the Official Gazette on August 8, 2019, plus 15 days, meaning this Act took effect on August 23, 2019.
Now, this is a very good law for everyone precisely because all those who are convicted from arresto menor to arresto mayors, or simply put, penalties 6 months and below, can avail the benefits of this Community Service Act. Now, here, the accused that are convicted by the court, instead of going to jail, are required to do two things. First is to do the community service program, and second is the rehabilitative counseling to be conducted by DSWD.
The Supreme Court issued the guidelines in the imposition of community service as penalty in lieu of imprisonment through AM number 200614 SC. Here it states that community service can be availed when the imposable penalty for the judgment promulgated is arresto mayor or arresto menor. So, after promulgation of judgment or order where the imposable penalty for the crime or offense committed is arresto menor or arresto mayor, court will announce the options of the accused. He can either file an appeal, apply for probation, or render community service. If the accused opts to file an appeal, this will then bar any application for community service or probation, which are the other two options available for him. And for probation, Even if the accused was previously granted of probation, this will not disqualify him to apply for community service as a penalty. Then, for community service, the following factors are taken into consideration by the court: the gravity of the offense, the circumstances of the case, the welfare of the society, and the reasonable probability that the accused shall not violate the law while rendering said service. Ms. Diktikan will then discuss the process if ever one opts for community service.
If the accused opts for community service, the application must be filed within the period to perfect an appeal. An application shall be resolved within 5 calendar days from filing. If the accused was required to post bail pending resolution of the application for community service, the accused may also move that he or she be allowed on temporary liberty under the same bond he or she posted, or the accused be granted recognizance as provided for under Section 15, Rule 114 of the Revised Rules on Criminal Procedure. Now, the court, upon receipt of the application for community service, shall notify the following officers. First is the barangay chairperson or his or her authorized representative of the barangay where the crime was committed. The second would be a representative from the provincial or city's probation office. The third would be the local government unit's social welfare development office. And the court may resort to electronic service of the notices for the mentioned officers. Now, the notice shall direct the barangay chairperson or his or her authorized representative to submit a proposed community service program for the accused on or before the scheduled hearing on the application. Now, the SWDO shall also be directed to recommend a rehabilitative counseling program and schedule for the accused that shall be incorporated in the barangay's proposal. In assessing the recommendations of the barangay chairperson or his or her authorized representative and the SWDO, they shall take into account that the type of program for the community service shall consist of physical activity which inculcates the civic consciousness. The second, it shall intended towards the improvement of public work, and it shall promote public service.
Finally, the court shall set a hearing to render or promulgate the ruling on the said application. The community service order will contain the following information: the details of the community service program, the number of hours to be accomplished or the period to complete the service, the referral of the accused to the probation officer, a statement requiring the concerned probation officer and the SWDO to submit a report within a specified time frame, and the imposition of additional conditions as may be warranted by the circumstances of the case. If ever the application for community service is denied, the accused can still choose to appeal the said judgment or apply for probation instead. It should be noted that the benefit of the community service law is only given once, and habitual delinquents are not allowed to avail this. The period for community service should not be more than the maximum sentence imposed by law, but not less than 1/3 thereof.